Good evening, everyone, and welcome to the webinar panel, New Policies to Increase Access and Choice for Students with Disabilities, What Parents Should Know. This is co-sponsored by Peak Parent Center, Collaborative for Exceptional Children. Thank you, Casey. Colorado League of Charter Schools and Colorado Association of Charter School Authorizers. I'm Pam Christie at Peak Parent Center, and I'll be monitoring the chat through the training. So if you could please introduce yourself in the chat and which city you reside in, then we'll know who's joining us today. And before we get started, I want to go over just a little bit of housekeeping. You will be muted for most of the presentation. Please use the chat to ask questions throughout. And we have closed captioning is available at the bottom of your screen. And if we have time at the end, we will open it up for Q&A as time is permitted. So we have Casey Coates, Executive Director from Collaborative for Exceptional Children, monitoring the panel this evening. Take it away, Casey.
Hello, everyone. Thank you for coming. I'm excited to see folks' names and locations dropping into the chat. I know folks will be hopping on as we get going, but definitely, as Pam shared, please drop any questions or comments in the chat so that we can be answering those and then following up with those if we need to, if we aren't able to answer them in real time. I'm thrilled to be moderating this panel, and we have a fabulous group of panelists. I'm going to start by introducing everyone. We have Paul Foster from CDE. He's the Executive Director of Exceptional Student Services. Dan Schallers, the President of the Colorado League of Charter Schools. Amelia Meunier is from Aurora Public Schools, and she is also on the board of CACSA, the Colorado Association of Charter School Authorizers. So she's representing that group as well. And then Bill Bethke is our renowned special education lawyer in the charter school setting. So he's just bringing with him all kinds of knowledge and experience, and we're thrilled to have him as well. All right, we don't have a lot of time, so we are going to just get right in and start jumping into this conversation. And before we do, though, I did want to give just a quick summary of the recent policy changes that we've seen through CDE. And this is all through our around enrollment, specifically in charter schools. But the changes that have taken place in the policy are around that application and enrollment period. And the first thing that you see here in this visual is that parents must be involved when there's a change of location. This is something that is really important. And when we're talking about special education students and their offer of FAPE, parents need to be involved. And so that's a change in policy that has taken place recently. The second one is that IEP process must decide placement. It is not something that can be just done separately, but it has to go through the IEP process. And then the last thing is that we cannot request or use disability status prior to enrollment. So when you're applying to a charter school or a school, or specifically a charter school, and there should not be any information that is being used for that enrollment that could be discriminated against. So if they are asking for an IEP status for like a choice enrollment, then there is a promise or an affirmation that information will not be used to discriminate against. But in general, we're asking that charter schools are no longer having that included in the application process. So that's just a summary, and you can see more detail inside of those boxes underneath. But wanted to start off with just the summary before we get started, and so that people understand what we're talking about. And we're going to dive deeper with questions specifically for the group into why we have needed this policy change and what's resulted from this. So let's get started. The first question is, how did we get here and why did we get here? What does this mean for all forms of public school choice? And I'm actually going to have Paul Foster start us off. Paul, do you want to unmute and answer this question for us?
Sure. Yeah, and Casey, I would add to what you said that this is really the recent changes to state rules really apply to all schools of choice. So definitely charter schools, but also choice options, in the typical K-12 setting. So that might, be a little extra information there. So how did we get here and why? So I think really it comes from sort of this tension that exists between a school district's obligation to ensure that students with disabilities who qualify for special education services receive a free and appropriate public education, or what we call FAPE, as many of you probably know. And then also this, the right for children with disabilities to have access or the same access to schools of choice, charter schools or other schools of choice, as their non-disabled peers. So I think that's really what led us here. I think the reality may be that children with disabilities weren't always given the same access. I think it comes from that concern, though, that the district has this major obligation, a significant obligation, to make sure that children with IEPs receive FAPE. In terms of what this means, for all forms of public school choice, I think it's a couple of things. First, I think that the change in the state board rules really try to make it clear that school choice options can't be determined based solely on whether or not a student has an IEP or not. So that can't be sort of this predetermining, decision, or it shouldn't and can't be used under the changes in the rule to kind of pre-screen or discourage parents from, exploring choice options, or even putting their name in the hat, putting their child's name in the hat for a choice setting. The other thing that I think that we're still going to need to understand is that school districts still retain that obligation to ensure that each child, each student with an IEP receives FAPE in the least restrictive environment. So districts can still make campus assignment changes. They can still look at the needs of the child and determine, if there needs to be a change. Now that change needs to happen through the IEP team now. And it also has to happen in consultation with the parents. And it really has to be more about, what justifies the need for that change of campus based on the child's IEP. And so I think that there are going to be more situations now where IEP teams are making this decision and looking at the needs of the child and determining where can that child's IEP best be implemented to ensure FAPE. So hopefully, I think what we're going to find out in most cases is that the school of choice can meet the needs of the child, and that child can be served, where that parent has elected. But there's still also sort of that maybe safety net, I guess you'd say, to ensure that the child receives the services that are necessary to receive FAPE and implement the IEP that's been designed by that IEP team, including the parent.
Perfect. And Amelia, do you want to jump in and share from more of a district authorizing perspective, the same question?
Sure. I would say part of how we did get here was there were a slew of OCR complaints that were filed by Disability Law Colorado. And they, what ended up happening with that, so what ended up happening with those OCR complaints, though, were this focus and attention on charter schools in particular around what their admissions policy and practices were, and what was the responsibility of districts to oversee and make sure that those processes and procedures were not discriminatory in practice. And so I think that's part of how we got here. And what this has meant for districts is paying attention to how charter schools, what is their choice enrollment process look like, whether it's a centralized through the district or separate lottery process. And so some of the things that we have done is look at making sure that there's non-discriminatory a non-discrimination process that is on websites, that they are explaining programming, that they're not asking for disability status. So in a sense, there has been more focus from authorizers to pay attention to what's happening in charter schools. I think that there also will be some processes being implemented across the state with authorizers as well, non-charter schools. So we'll be looking at those pieces. But the idea, and I believe the hope, is that this does increase enrollment across charter schools, in that by not asking ahead of time to pre-screen or look at an IEP, that makes the process more blind, in the sense of you can look at programming and look at a variety of other pieces before you're making decisions about whether a school is a good fit for a student or not.
Thank you. And Dan Schaller from the Colorado League of Charter Schools would love your input on this question as well.
Great. Thank you, Casey. And good to see everybody this evening. As Casey said, I'm Dan Schaller, president of the Colorado League of Charter Schools. We are a support organization that provides assistance to the vast majority of the state's 270 charter schools across a number of different areas, but definitely in the area of special education as well. I guess I want to first off start by saying that we have a lot of work to do in this state in public education in general, particularly when it comes to serving students with special needs. And we recognize that we are a critical part of that in the charter school community, and we are committed to doing our part to better serve students with special needs and make sure that parents and families, particularly of students with special needs, have access to school choice options in the same way as other students and families across the state. I think in addition to what Paul and Amelia were saying, I think one thing I would just add is that historically there have been some interesting structural factors that have sort of contributed to some of this. I don't want to say this is the only factor that has contributed to it, but Paul alluded a couple times to that obligation districts often have, or they have, around fate. And in my view, that has oftentimes contributed to a situation, or sometimes contributed to a situation where some certain practices have maybe become ingrained or in charter schools' minds and mindsets. But I think that's where the rules that were recently adopted are powerful, because they offer some strong clarifications around when is the right time for schools to be engaging around these sorts of things. So for now, maybe I'll leave it there, but excited to be here this evening and grateful for the opportunity.
Thanks, Dan. And as we said to everyone earlier, I know we've had people join in. Please feel free to drop comments or questions in the chat. Panelists, y'all are welcome to answer questions as we go in the chat, but we'll also, if they are great questions for the group, we'll try to hang on to those for at the end. All right, let's jump to our next question. How does this impact families of students with disabilities? And for this one, again, I'm coming to you, Paul. I want to have you start us off on this one.
Sure. Yeah, so I think this is a couple of things. I think this means that we're moving toward more equitable access for students with disabilities, the various choice settings. I completely concur with Dan. We have lots of work that we have to continue to do here in the state of Colorado. And I think this is exciting, in the sense that children with IEPs, children with disabilities who qualify for special ed, I think we're moving toward more equitable access. And I think what that'll ultimately do, I think it's going to increase some positive pressure on schools of choice to figure out ways to serve students with IEPs. What I think is probably a little ironic about this is I think many of them already have the capacity to do that. But I think this is going to, kind of build in incentive that will, give them, reason to think about what services, what supports, what do they already do that's very conducive to meeting the needs of children with disabilities, specifically those kids with IEPs. But I think it's also going to, kind of shine the light on where schools may need to grow in some areas in order to provide those services that students with IEPs may have. I think the second part of this is it puts a lot of responsibility also on parents to have a deeper understanding of why their children may be in certain programs within their current school setting or different kinds of educational settings or programming, because all students are general education students first, and we really should only be moving away from that when the IEP, the goals and objectives in the IEP, the services called for in the IEP, they really, those are the types of things that need to be provided for a portion of the day or for a good chunk of the day, whatever the individual needs of the child may be outside of that general ed setting. So I think it's going to be really important, for parents to understand, the why behind their child's program. I think if they do that, that's going to kind of make them, for lack of a better word, maybe better consumers. They're going to be looking for programs and schools that are better matched for their child if they understand the current needs of their child and the current programming that's in place. So I think that's going to be key. As parents look for options, they are looking for options that are a match for the needs of the child.
Perfect. Sorry, I couldn't find the mute button. Perfect. Thank you so much. I think that's actually a key takeaway that I'm going to hang on to. I'm going to reiterate again here at the end, because I do think that's important that our parents are feeling equipped to be able to advocate on behalf of their kids and also navigate the many choices that they do have. So, I think that's a huge piece, and I appreciate for you bringing that up. Bill, Becky, our resident lawyer, want to come to you. Would love for you to chime in on this question.
Sure. Maybe I preface directly answering the question by saying I think we already have a significant number of schools and districts that are doing this pretty well. The idea of not pre-screening and of using IEP processes for placement and of presuming that choice is appropriate for parents of students with disabilities, and you only move away from choice enrollments if you've got sort of compelling educational reasons for doing so. That's already in operation in a lot of places. And what we're trying to get now is the best practices spread across a larger body of schools and a larger body of districts. Having said that, I also think I want to pick up a little bit on what Dan said about structural issues and what Paul said about parents becoming, I don't like the word consumers because I don't think it quite captures the relationship between parents and schools, but becoming smart about exercising the choices that they make. And I want to kind of introduce in two different ways the concept of looking for alignment. I think we've got a lot of charter schools that need to figure out, and a lot of traditional public schools that need to figure out how to align their regular education curriculum, their regular education methods, and sort of their pedagogy with special education. We've tended to have a situation in which the charter school delivers regular education and the district delivers special education or a substantial share of special education, even if it's in the charter school. And those two sometimes work hand in glove, and sometimes they're very awkward in relationship to each other. And this is really a chance for schools to figure out how to do special education better in the context of of their regular education approach. And how to identify, we always talk about the students who don't fit or the students who struggle in a particular type of school, but what we ought to be looking for is the students for whom a particular type of regular education is kind of an exceptional fit and really does something good for a child who may have special needs. So I think it's a chance for the school to try to align those two things. And that also comes back to Paul's comment, because it's the parents need to become sophisticated about this issue. And a lot of parents are already pretty sophisticated about their child's special education needs, but this is an additional step of thinking about how that relates to regular education. What is it about a Montessori program that's good or not good for a particular child? What is it about expeditionary learning that works or doesn't work for a particular child? And what do those words, Montessori and expeditionary learning, mean? And I'm not going to go into that because we could spend all day on that. And there are a lot of other, obviously, regular education programs we could talk about. But it's an opportunity for parents to look at choice on a par with what they would do for their child who doesn't have a disability, and to assume that their judgments are going to get respect and will only be questioned if there's some difficult issue that's presented by the particular choice that they've made.
Yep, I really appreciate you saying that. I also though want to add, add on to that, building onto that, as we're thinking about alignment or figuring out, where a child will thrive. I think that we really are hoping that our parents are the ones who are leveraging that knowledge and expertise of their kid to figure out where their child will thrive, navigating the system. And I think, in the past, we've had situations where a school is the one that's defining whether this is a good fit or not. And so ideally, and I'm not disagreeing with you, I'm adding on, I think we'd like to see parents being the ones figuring out what's that best alignment for their child and figuring out where their kid will thrive. And that's hard. I think that's a hard one. And but I think that's an important piece. And I appreciate you adding that.
Yeah, no, I agree with that, Casey. And I would say we really need parents to be thoughtful about, sometimes we have parents who know that they're not happy with a particular program that their child is in. They know they want to find something else. And there may even be a certain level of frustration or desperation in trying to get away from that program and not use due process or other legal mechanisms to do so. Choice is an alternative, right? I mean, you can choose to exercise the voice mechanisms within IDEA and within 504, or now you can choose to seek another environment. But you ought to be really thinking carefully, not about just getting away from program A. You ought to be thinking about what's the place that's really going to help my child flourish.
Yep, I love that. Thank you so much. All right, let's move on to question number 3. How are charter schools responding to this change? And I'm coming to you, Amelia, given your role in authorizing the charter schools in Aurora Public Schools. Would love your insights on this one.
Well, we're definitely seeing charter schools reaching out for guidance on how to approach this. They've updated their processes and procedures to not ask about disability. I think some of the questions they're asking us are, when a parent discloses that their child has a disability, how does that information inform or not inform? And so sort of some of the pieces we're talking about is it's fine for a parent to disclose a disability, that their child has a disability. However, it cannot be used as a way to screen out a student from a school. And schools really are thinking through opening their enrollment and doing that practice now to ensure that they're not discriminating, and they are needing to think through how do they adjust and serve all of the kids in their building within the program that they have. What adjustments do they need to make that they can provide a continuum of services within their building, and I think they're realizing that they can serve the majority of their students regardless of disability, and that students are general education students first. And I think a lot of schools already were in that space, but I think now they're coming to some more understandings and trainings that I've seen school leaders in. Oh, I didn't realize that that might be perceived a specific way by asking, or some of the feedback that they provided parents might have made parents cautious or question whether they wanted to pursue enrollment. So I think schools really are responding positively to it and are trying to adjust and make sure that they're following the new guidance in districts and reaching out to districts for support with that.
Thank you. And Dan, do you want to share from the league's perspective?
Yeah, so I would piggyback off of something Amelia was just saying right there. My experience with our schools has been that they have been reacting or responding positively to it, in the sense that it provides some much needed clarity. What we were finding more often than not is that there was just inadvertent confusion previously. So to the degree schools were perhaps asking questions at wrong times in the process, a lot of it was inadvertent. A lot of it was practices that had been adopted because of some of those structural factors that we were talking about before. So I have been pleased to see how the charter school community has been responding, and the degrees to which the charter school community has been cleaning up processes or cleaning up websites that may have had language previously that was not as welcoming and inviting as it could have been. And we have been, even prior to the rule change, we have been working to try to proactively help schools address this, and have been offering enrollment reviews to schools, working with Casey on that, to proactively look at their practices and their policies. And so I think this has provided a nice additional push around that to further clarify what the right timing and the right process is for these situations.
Yep, I can totally second or third that. I do feel like we're seeing a lot of great efforts from schools to get better at this. There's a lot of willingness to be vulnerable and recognizing what skills need to grow and what areas need to get better. But I think in general, I'm seeing a lot of schools that are really trying to do good work in this area. So perfect. Let's move on to the next one. And as a reminder, we are coming close to the end of the questions we've created. So feel free to drop questions in the chat if you have those for us. All right, so question number 4. What process should a parent expect to go through when applying to a charter or choice school? And I'm going to come to you again, Amelia, on this one.
Sure. Processes a parent should expect to go through, really, it's open enrollment. There a lot of charter schools have a lottery, and so you would enter into that lottery and put put the information for your student in there, and then you would from there you would wait to be offered a seat. So if it's a blind lottery, so you should your child should be able to get in there just as equitably as any other student. And once your child is offered a seat, and you're going through getting enrolled, so you're offered a seat, you already know that there's a spot for your child. That would be the time that a school can ask for the IEP, but that IEP should be looked at, and then they're thinking about how they're providing services to your child within the school. Rather than saying to you directly, we can't serve this IEP early on. There are situations where that may be the case, but for the most part, most schools, charter schools, can serve a variety of students' needs within the setting that they're in. Trying to think of other processes. Once your child is enrolled, they're enrolled. If there is a situation where there's questions, there's considerations where the IEP indicates that your child might need some more extensive services that aren't provided in a mild moderate setting, then you need to be part of that conversation and invited into those meetings. So you should be able to anticipate being part of the meeting. Whereas in some districts, past practices where districts made those decisions and then informed the parent where there was opening for your child to go. This sort of flips that upside down and indicates that the parent needs to be part of that process through the IEP process, so that you are in the loop all the way through, rather than a district making that decision for you.
Thank you, Amelia. And now let's go to Paul again.
Yeah, really, mostly to just echo that, each district and the charters, they'll retain the process. They get to decide how they do it. So I can probably better speak to what you shouldn't see, and that is, you shouldn't see any questions about your child's disability status or IEP during the application process, unless you're in a district, and some of our really large districts, I think, have this, where there is this centralized enrollment system. And then districts should be issuing statements that ensure that that's not used as a part of the placement decision. So, that would be the only exception that you might see that. So like if you're in a DPS, there's this large centralized enrollment system by which, parents indicate what schools they want to go to. That might be that's an exception to that rule. But again, it can't be used as part of the decision making. And then, yeah, after the child is in that setting, or after that child has been admitted, that's when schools can look at IEPs, request IEP records, just like they would any student's records. And then, if necessary, the IEP team can be reconvened. So really, I don't have much to add to it other than just to echo what was already said.
Perfect. And, you know, I would add to that, I do feel like as we're navigating these rule changes, you know, we've had a few situations where the IEP is saying a different level of severity than the parent is feeling like their child has. And I know, Amelia, you and I have talked about a situation. Do you have any insights from on what should a parent do? How do they advocate when they are changing schools, but the current IEP is showing a level of need a level of need that's higher than what they feel is necessary? Do you have thoughts on that, Amelia? Sorry, I'm putting you on the spot.
No, that's okay. I do think it's really important for parents to advocate throughout the IEP process. So prior to switching schools, wherever you currently are, making sure that you are reading the IEP or having an advocate sit with you so that you understand and can ensure that the IEP really does reflect your child's needs, so that it's not so that the IEP really does reflect it, the student's needs, so that when you do go into a new school, that you can feel confident that what is written in the IEP really does reflect your kiddo's needs. And I think that's a pretty critical component. Sorry.
Don't we all have that dog? So we totally understand, Amelia. Feel free to finish. Or
I think it's important that you're aware and you advocate. And if you struggle, you know, some of our parents are English language learners, or our students are, making sure that you have interpreters there, making sure that you have folks who can really support you. And there are family advocacy organizations that can help you navigate the process if that's hard for you.
That's a great answer. And then on the professional side, I would add those of you, because I know we have a few professionals, a few educators joining us today. I would also add, this is an opportunity to kind of problem solve individual cases and take time to really get to know the situation and look at the IEP and talk to the family and do your best to try to navigate. Sometimes there are challenges with what's on the paper and what's being told to you. So working collaboratively with the family and other organizations if needed to navigate those situations. Perfect answer though. Thank you so much, Amelia. Thanks for letting me put you on the spot. All right, next question. Does being enrolled mean my child with a disability gets to attend that school? And Bill, I'm going to come to you on this one.
Okay, I think the answer is probably. It's not just maybe, it's more than maybe, but it's not a certainty. You know, it's already been stated several times, the vast majority of children with disabilities are able to be served in a wide range of schools, and a wide range of schools are able to serve most children with disabilities. But there are exceptions. There are children whose needs are more pronounced or are specialized in some way. And what this rule really says is not that we overlook that or that we ignore that question. We're not allowed to do that under federal law. What it says is we go through the kind of protected space of the IEP process in order to make those decisions. You can think of it, I'll use a little bit of legalese. In regular ed, we talk about enrollment and we talk about choice enrollment. In special ed, we talk about placement. And there are situations in which placement trumps enrollment. They're going to be infrequent. We hope they're going to be, if anything, rare, but they will occur. And the good part of that is there has to be a discussion with the parent. There has to be an opportunity for the parent to be engaged in that conversation. and the parent has recourse within that process and through appeal outside of that process if they're simply unhappy with the conclusion of an IEP team that says their choice placement is not providing FAPE or is not able to provide FAPE, and that the child needs to be placed somewhere else. So it's not an absolute right, but it's a pretty strong presumption, and it's going to mean that in most cases, that choice placement is the one in which the child is educated.
Thank you. Amelia, would you add anything onto that?
I would just add that it's really important that that you understand that there are some circumstances, but for the majority of the time, again, Bill already said this, that the majority of the time the school can serve that student, and making sure that you're part of the conversation is a piece of that, right? Understanding you as a parent should be able to understand why your child may not be able to be served in that setting. And so you are part of that conversation, and making sure that you fully understand that and that you have some input into that process.
Thank you so much. And I'm seeing Paul. Paul, do you want to give any more details to what link you just added into the chat?
Yeah, sure. So the Department of Ed has some resources for alternative dispute resolution. And that's a resource that's it's meant to be non-adversarial. It's meant to support the IEP process. It's really meant to ensure that all voices at the table are heard. And so that may be an option, for some parents. I do think that, what Amelia was saying about the importance of the IEP being an accurate reflection of the child's needs, that's really that's key. And so we understand that sometimes there are conflicts and that there are disagreements, and this is one of the things that we offer at the department that tries to resolve. Doesn't ignore the fact that there are problems or disagreements, but it's a way to facilitate it in a more non-adversarial way. And of course, there is dispute resolution, where there's state complaints and due process and different things like that that are available as well. But this is a way to hopefully address the issue at lower stakes, lower tension level, maybe.
Yep. Thank you so much for adding on and adding that link. All right. So we have finished all of our questions that we've developed in record time. I'm so impressed with us, leaving plenty of time for y'all's questions. So I'm actually going to stop sharing my screen so I can see people a little bit better. And panelists, like I said before, as we start sharing some of these questions, Pam's gonna ask the questions from the chat, and then if you want to unmute, and we'll call on you, so that way we're not speaking over each other.
Thank you. So the first question, is it legal if a student has been accepted into a school and then their needs escalate for the school to change school placement?
All right, Bill, go ahead.
The answer is it depends on how they do it. It is not legal for the school to just unilaterally announce that the student's placement needs to change. But if they need to initiate an IEP process to discuss the student's IEP, things that can be discussed in that might be changes in services, might be changes in how things are done in the school. But another item that could be discussed is we think that there's a better option outside the school that should be used in this circumstance. And so I'm oversimplifying, but if you go through the proper process under IDEA, then that answers the question of whether you should or should not change the placement and whether you're doing it properly or not. So parent participation is going to be key, but yes, it can be changed.
Thank you. Second question.
Oh, wait, hold on.
Level-
Paul, do you want to add on to that?
Yeah, just number one, to echo exactly what Bill said. And then second, I'm going to say that typically the first IEP meeting that happens if things begin to change in the child's, behavior, needs, whatever. That the first meeting probably shouldn't be about we need to move your child. There probably should be other IEP meetings along the way about discussing what other types of services may be appropriate. Do we need to, if we're talking behavior, because that's often, a concern, have we done a FBA, a functional behavior assessment? Have we developed a BIP? Have we tried some things, along the way, to make the child successful where they're currently being served? So yes, absolutely, that it should be a part of the IEP process. And usually there's some things that, should at least be considered before making any kind of move. And there may be some situations where, for whatever reason, in that individual child's need, you do need to make that decision sooner than later. But it's probably important to consider other options prior to that.
If I can just add one other thing that Paul's comments brought to mind, there's also the possibility that you could be talking about temporary movement to another placement in order to do some special work with the student in order to bring them back. So it's not just a binary choice. It's much more complex in that you can change the program that in the school, you can do some temporary placement and have the student come back to the school, or it may be something that ultimately ends up being a permanent change of placement. All of those are possibilities.
All right, next question, Pam.
Thank you. What level of services are we as a state expecting charter schools or schools of choice?
I'll take a stab at it. I'm sure other people have thoughts. I think it's a mistake to think about it in terms of level of services. IDEA is about individualization. And there may be a child who has what an IEP calls moderate needs, who is just falling apart in a school system, and another child who has profound needs, who's doing just fine in a charter school. So, yes, you could have a rule of thumb of some kind or try to arrive at it, but it's really, I think, it's not the right way to think about the problem. You also have schools with vastly different resources. If you're talking about a tiny school up in the mountains that has 2 teachers and 13 kids, what they can do is completely different from one of our charter networks, or in the Denver area that's bigger than 100 districts in the state in terms of student enrollment. So, just as small rural schools are a different proposition from big urban schools and big urban districts, small charter schools can be, and very specialized charter schools or other kinds of schools of choice can be a different proposition from each other. So, I just don't think we should try to have a generalization. It's all about the individual student.
Great answer. Anyone else want to add more to that? And thanks for jumping in while I was trying to find my screen again. Amelia, do you want to add more?
I would just add that for the most part, charter schools really can and should be thinking about their programming and how they serve kiddos differently. With some adjustments, a kiddo who may have been unsuccessful or having some challenges with some adjustments can do really well. So, I have heard different components. We only do the co-teaching model. We're a college prep school, and the student doesn't read at a college level or a high school level, and they need too much. We can't do that. Whereas really, under IDEA, the onus is on the school to provide a continuum of services, a variety of different components that allow the student access, and there's a variety of ways to do that. So I do think this is going to push charter schools to be thinking about what is their continuum of services to meet a larger variety of kiddos in order to have equitable access to charter schools.
I'll just jump back in. What Amelia said, kind of inspired another thought, which is we tend to look at this through the IDEA lens, but you can also look at it through a 504 ADA lens as a question of non-discrimination. And what Amelia was just talking about sounds to me like a question of reasonable modification. Are we making reasonable modifications in order to accommodate a child with a disability. And if you look at the federal rules on that, the space for saying in education that there's an undue hardship, or that there's a change in the essential nature of the program that justifies not making an accommodation because it makes it unreasonable, is actually very narrow. And so, there's a strong presumption that you're going to serve a broad range of students, which is another reason why I think the whole thing of, mild, moderate, significant, severe, profound is just the wrong way to think about it.
Agreed. Thank y'all for those answers. Pam, next question.
If a child needs to be removed from their neighborhood school, do parents still get to participate in choice of where they are placed?
I think that's a good question.
I hate to keep jumping in, but these all sound like legal questions. That's a great question. Unfortunately, a full answer would be pretty complicated, because we'd have to talk about the different kinds of removal. We'd have to talk about the state law regular education process for expulsion, how that sometimes applies to students with disabilities, because students with disabilities have been known to consciously misbehave. That they have agency like the rest of us, but sometimes doesn't apply because we consider their behavior to be a manifestation of their disability, and then we're in a whole different process under IDEA or potentially under 504 in assessing what options the system has for responding to what would normally be reasons for removal from a regular education environment. So it's the short answer I can give you is that it's all treated in a great deal of detail in both state and federal law. They're interactive and they're complex, and it's a great time to call your lawyer. And that's not trying to increase, not trying to do full employment for lawyers, but those disability behavior questions get technical and get complicated.
That's great. Paul, did you want to add anything, or?
No, Bill said it much more eloquently and probably succinctly than I would have. So yep, I think he covered everything.
All right, next question.
If a district or a charter school does something that does not seem to align with these new rules, what should a parent do?
Paul, I'm coming to you on this one.
Yeah. So these rules live in the Exceptional Children's Education Act governing regulations. So these are regulations that are passed by the State Board of Education. So, I'm going to say, first thing is always, to try to, resolve the issue at the local level, do what you can there. But, really at this point, I think you have a couple of options because it actually lives within our rules. I think it could probably be something that would be a state complaint. That's a possibility. It could also, I think, continue to be an OCR complaint. But again, I think, probably, the best thing to do is to, work at the local level. We do have many advocacy, groups within the state that, can support you. Peak is, has great parent advisors, who can support. So I think, we've tried to disseminate this information far and wide so people understand, but it could even be something as simple as, for whatever reason, that person who you're talking to at the local level just hasn't gotten the information yet for whatever reason. So I think, you kind of assume that there's probably a misunderstanding on the front end. You try to share the information, with, the schools to make sure they've got, they understand, perhaps then, reach out to, advocacy support that you may have accessible. The ARC has a lot, across the state. And, those are things that can resolve it at the local level. And then, ultimately, there could be a need for a state complaint, potentially an OCR complaint. Unfortunately, those processes take a long time. They're not quick. We do operate under deadlines or timelines, I guess, for the state complaint process. But again, it's adversarial, and it can also, take longer than, maybe is in the best interest of the child. So.
Thank you. Amelia, do you want to add on?
Yeah, I would just add that similar to what Paul was saying, is escalate it within the school, because there really may be somebody who just is not aware. And if that's not successful, you can escalate it within the district. And even if it is somebody within the district, they too may not have the right information. You can always escalate it to the director of special education within the district. And my guess is at that point, you will see some of this addressed at that, because they have been provided this information extensively and had conversations for sure. So that would be the best way that I would think about it. And then of course, if you are not getting answers that align to these practices and these rule changes, then escalating that to, advocacy and or OCR or state complaint. But I do think that there are resources to escalate that up within systems.
Mm-hmm.
Yeah, and I would, Amelia, thank you for saying that, because that brought to mind, many times when I'm talking to parents, I ask them, have you talked to the special education director? And either they haven't, or they think they have, so on our website, there is a place to find out who is the special education director for your administrative unit. I'll even drop that in the chat so that you can make sure that you're talking to the special education director, because that is our source of contact. We don't necessarily, have the opportunity to communicate with superintendents or campus administrators and those folks, but our special ed directors, know this, and it's not unusual, frankly, for a special education director to not know there's a problem until there's a complaint. And so that's not always the case, but it's not unheard of for the special education director to say, I didn't even know there was an issue here, because either people in the school districts didn't tell them, or the parent never was able to make contact for whatever reason. So excellent point, Amelia. Thank you for saying that.
I would also add, if it is a charter school that you're running into this with, we are doing a lot of work with our charter schools. I know Dan at the league, we have league members, and so they have access to free consultation for special education things. And so when we do get word that there is a conflict or challenge, we are often supporting schools through that. So if you have run into questions or concerns, you can reach out to us, and that might be a way for us at the collaborative or the league to be able to support as well, because maybe the school has not been trained or has not learned that this is a new requirement, or you're talking to the wrong person. I know Alex and I have done a really fabulous modeling of a front office staff and a parent to be able to show what that relationship should look like, or that conversation could look like. But a lot of front office staff have not been trained. So like they've said, definitely talk to the right people. So move to the special educator or the principal, or and feel free to reach out if you would like some additional support. We're probably one more question, Pam.
Yes. Do the new rules cover students with 504 plans too?
That's a good question. Paul?
Yeah, the rules, I think the rules govern children with IEPs, in terms of the ECEA rules. However, I think the same non-discriminatory kinds of expectations exist for the 504, the kiddo with the 504 plan. So what we're charged with at the state level is really, more the implementation of the IDEA, the Individuals with Disabilities Education Act, and the ECEA. And so kiddos, so, we don't have that same level of jurisdiction over 504, but I think basically the rules apply, yes, in terms of non-discriminatory kinds of rules. So Bill, I'm going to punt that over to the lawyer and let you comment on that too. So,
Well, I think I would say that it's probably always been a credible 504 theory that you had to behave in this way. And the difficulty has been that it wasn't as clear perhaps under IDEA. And so what we're really doing is we're taking non-discrimination concepts that are natural under 504 and the Americans with Disabilities Act, and we're making sure that that aligns with our rules under IDEA. So individual cases could get complicated, but I think, yes, the basic answer is you can assume something very similar, not laid out in exactly the same way, but similar in principle is going to be the case under Section 504. And also, there's going to be an even stronger presumption under Section 504 that a kid who is not on an IEP, who's on a 504 plan, is able to be served by just about any school. I'm sitting here trying to think of an exception, and if you give me a couple of weeks, I might come up with one, but it's going to be a pretty strong presumption under Section 504 that you can provide that service. We do have some cases in which parents disclaim IEPs. They exercise their right under IDEA to say, I insist my child not be on an IEP. 504 is still going to apply in that circumstance, but those aren't really, some of those kids at least are not really 504 kids. It's just that they've been pulled out of the IDEA by their parents. So that might present the more complicated issue.
Amelia, did you want to close us up on this one?
I would just add that as from the district perspective, what we have asked our charter schools is take out non-discrimination language. So that applies to any potential disability, any 504, any IEP, but also any identifying factors that a student could be discriminated against. Ethnicity, race, all of those pieces we've asked to be taken out of those enrollment questions so that and make sure that there's a non-discrimination disclosure on websites so that that if there are any questions, that any information gathered would not be used to discriminate against a student's enrollment.
Perfect. Thank you, Amelia. Michelle, I'm going to have you. Did you have one thing to say
just
before?
real quick, 'cause I do want to end on time, and I apologize. So first, I just want to say thank you. I know everyone on this panel are very busy people. So thank you for being here tonight. It's really an honor on behalf of Peak. And I think that leads to my question of moving forward, how do you see Peak being supportive in this role? And what is the next phase? I know this kind of was more introductory, right? The new policies came out. I know when Alex and I started and we got the team together, that was the vision. How can Peak help support the process moving forward and all of you on the journey?
I can speak from my perspective. I do think we have a lot of parents. I've interacted with a lot of parents who need support in this, and so I do feel like it's more than just our webinars, which I think the fact that we're doing these together is great. But I think thinking strategically how we could work together to provide more supports to our parents who are navigating this, especially those that are speaking different languages, have different knowledge and experience with special education. So that was my thought. Anyone else want to add anything? Feel free to unmute. I can't see y'all right now.
I would just say making sure that Peak Parent understands and that you're seeking out information so that we can support you all in understanding, so that you can also support the parents that you work with should you hear of anything or come across anything that that might be helpful for them to know. So I think because you have access to the parents, having you understand it is a really critical liaison position, unique position that you have with parents to help support this work.
And I think you guys are uniquely positioned to distill this down into, parent-friendly language and take a topic that can feel, perhaps daunting in some respects, and make it accessible. And we try to do our part in the charter school landscape of making resources that will help the charter schools navigate it, and you guys are uniquely positioned to do that with the parent community.
All right, Pam, do you want to close this up?
Yes, thank you all for joining. Thank you, Casey, for moderating, and the wonderful panelists for the informative session. You will be receiving a training evaluation after this presentation. We would appreciate if you would take just a few minutes to complete that and provide your feedback, as we always strive to improve services here at Peak. I know there were quite a few questions that we were not able to get to. Our apologies. Please contact a parent advisor at peakparent.org. I put that in the chat, or 719-531-9400. Check our website, www.peakparent.org. On behalf of Peak Parent Center, thank you so much for joining, and have a good rest of your evening.